When it comes to estate planning, there are three huge misconceptions that I see year after year, over and over again, all the time. And I want to bring those up to you. Number one, a will keeps assets from going to probate. That is not necessarily the case. I always tell people a will is what gets used if something goes to probate, not to keep it from going to probate. So a judge has something to look at to say if something goes in there that it wasn't titled properly or there was no beneficiary, the judge has a document that shows your wishes of what would have happened if something does end up in the probate courts. Okay? So remember, a will doesn't keep something from going to probate, it's just if something goes to probate. You need to make sure that you have proper beneficiary designations because those will always trump what your will says. Number two, a trust is only for the rich. That is not the case. There are some trust structures, of course, that are built and utilized by the ultra high net worth people of our country. But a basic revocable trust is something that gets used by people of all income levels and net worth levels. Remember, a trust gets created because you do not trust. Remember that. And this could be for minor children that you have that you're not confident would be able to manage the finances responsibility if, God forbid, something happens to you or your spouse. And because it could be because you have a child with special needs who you know is never going to be in a position where they can manage financial affairs on their own. Or you just have a child that you do not trust because they are really bad with money, or they have a spouse that you do not like or trust with money, or because they have something like a substance abuse issue or addiction. And you know that if money came into their hands, it would all get blown on something. So a trust is created because you don't trust for a variety of reasons. It can be used for people at all asset income levels, etc. Number three, if you have a spouse, they are automatically your power of attorney. This is not the case. Okay, this is something that I learned early in my career working with a family who they didn't assume that, but they just didn't get their documents done. And the spouse had to apply to be their guardian. And guardianship is a mess. You have to get the courts involved. There's all these restrictions, and you can simply avoid this by creating powers of attorney, both for financial and healthcare, that name each other and allow you the ability to act on each other's behalf, whether that's today while you're of sound mind or only upon incapacitation. But it is so important that you get these documents done so that you are not leaving life up to chance and getting involved with the court system if, God forbid, something happens to either one of you. And those are the three biggest misconceptions that I hear over and over again when it comes to estate planning.